also exacts certain costs through the lack of democratic checks and balances. For one, the ATS places few limits on who can bring the suits. By its terms, any alien can bring suit, and often suits are brought by aliens who have no presence in or contacts with the United States. Unlike criminal cases, which are subject to policy and political checks through the exercise of prosecutorial discretion, SOSA has not, or at least not yet, provided an effective restriction on the types of claims asserted under the Alien Tort Statute. Indeed, the American bar is actively soliciting new alien plaintiffs to open up new areas for Alien Tort Statute claims, for instance, in the area of environmental litigation. More broadly, the lack of a predicate judgment by the political branches that such suits should be brought is a significant problem. As I noted earlier, Congress, in the context of the Alien Tort Statute, has provided virtually no guidance to courts as to how to define causes of action under U.S. law based on international legal norms. The modern ATS is mainly the product of judicial decision-making. This fact was noted by the Supreme Court in SOSA and was clearly part of the reason for its restrained conception of the statute. Furthermore, unlike the limited and specific nature of 18th century law of nations offenses, such as piracy, international law today has developed significantly and comprises a significant and somewhat unwieldy body of norms. Alien Tort Statute plaintiffs nearly always rely on customary international law. And as a practical matter, then, management of ATS litigation depends on the least politically accountable branch, the judiciary, interpreting an ill-defined body of law, customary international law, that is the president's responsibility on the international plane, and that unlike statutory or treaty law, is not the product of a formal legislative or executive process. The text of the ATS does not provide for a formal role for the executive branch in ATS litigation. Here, it's worth comparing the role of the executive in policing the terrorism exception to foreign sovereign immunity. Now, as many of you are probably aware, under the Foreign Sovereign Immunities Act, or FSIA, foreign states are generally immune from suit subject to certain exceptions. In 1996, an exception was added for suits based on acts of terrorism. And whatever that terrorism exception's merits, in enacting it, Congress took some account of the fact that it could complicate the president's conduct of foreign affairs and gave the executive an important role in the application of this exception. So rather than permitting suits against any state based on allegations of terrorism, only states that were designated by the president as state sponsors of terrorism lost their immunity as to terrorism claims. While litigation under the terrorism exception presents some of the same problems raised by ATS litigation, the fact that the executive has a role in the scope of that litigation has helped to limit potential frictions between the courts and the executive arising from terrorism-related lawsuits. And of course, the FSIA exception was the result of an affirmative act of Congress, which has the authority and the political accountability under the Constitution to define the law of nations and the jurisdiction of federal courts. As I've said, the executive branch often participates in ATS litigation as an amicus. Such filings are made by our Justice Department in coordination with my office at the State Department and as appropriate with other parts of the U.S. government. Sometimes, especially in the district courts, filings are made in response to an invitation from the court to express the views of the United States on the particular litigation. Those requests are themselves a sign that Alien Tort Statute litigation is putting the courts in an awkward position of adjudicating issues touching on U.S. foreign policy. If an area of the law is so fraught with such risks to broader national interests that it requires courts to regularly seek the advice of the executive branch, perhaps courts are being asked to delve into matters that are not well suited for litigation in U.S. courts and are more appropriately addressed by other means. Such case-by-case participation also puts the executive branch in a difficult spot. Foreign governments continue to press U.S. administrations, Republican and Democrat, to weigh in on their behalf in Alien Tort Statute litigation. If the executive is expected to weigh in when litigation presents foreign policy concerns, courts may come to infer, wrongly, from its silence in other cases, that there are no such concerns. So it puts the pressure on us to file something in every one of these cases. In addition, foreign governments may come to regard the executive's decisions whether or not to file as a reflection of the United States' view of its bilateral relationship with that government. In other words, if you really like us, you will file on our behalf in the courts. Domestically, foreign policy submissions will often be read as partisan support for the activities of foreign governments over the deserving interests of the plaintiff victims. So we essentially look like we are bad guys if we file on a legal principle on behalf of a foreign government. But despite the problems of case-by-case participation, the executive branch has real interests in ensuring that as a matter of policy, ATS litigation does not interfere with its conduct of foreign relations. I've already noted foreign governments' concerns about the scope of U.S. court jurisdiction under the Alien Tort Statute. In addition, recent ATS suits have been used by litigants to duplicate, replace, or proceed on top of the U.S. government's own efforts to reform foreign government practices or help end foreign conflicts. Often these suits are brought as class actions for all aliens injured by the challenged conduct, effectively asking the U.S. courts to serve as administrator of an international claims program for foreign nationals. This is illustrated by the nature of the claims in the Apartheid and Falun Gong cases, in which the plaintiff classes potentially comprise millions of South Africans and Chinese, respectively, filing complaints in our courts. Cases such as these tend to directly implicate broad U.S. foreign policy concerns. But without a formal role in the statute, the executive's participation through statements of interest and amicus briefs is one of the few practical ways that the United States can seek to confine the scope of the Alien Tort Statute in a manner that is faithful both to its limited historical roots and the restrained conception of the ATS explained by the Supreme Court in Sosa. Compare, for example, the Torture Victims Protection Act, or TVPA, which is a somewhat similar statute. Congress enacted the TVPA in 1992 to provide an express cause of action for aliens or U.S. citizens to sue for torture or extrajudicial killing committed under the color of foreign law. But enacting the TVPA, Congress included several important provisions that were requested by the executive. Accordingly, that statute requires exhaustion of adequate and available local remedies. It limits suits to conduct by state actors, essentially government officials, and it also provides for a 10-year statute of limitations. The TVPA is far from perfect, and it can have the effect of thrusting U.S. courts into foreign relations. But it is the result of a legislative process, one that resulted in several limitations in the TVPA that take account of U.S. foreign policy interests. For these reasons, there are fewer occasions for the U.S. to file statements of interest or amicus briefs in the Torture Victims Protection Act litigation. But in contrast, the U.S. government's practice of filing statements of interest and amicus briefs in so many ATS cases can be understood as a necessary substitute for the fact that there was never a legislative process resulting in an act of Congress creating causes of action for the assorted international norms that plaintiffs have asserted under the ATS. Going forward, we need to consider how to limit the costs of the Alien Tort Statute, both diplomatic and democratic. A critical first step is to recall the ATS's original purposes of providing foreigners an adequate means of redress for other offenses committed in U.S. territory and perhaps on the high seas in the case of piracy. ATS actions should be confined to situations that closely resemble the types of suits that the first Congress had in mind. In addition, to the extent that causes of action are allowed under the Alien Tort Statute, it would make particular sense to bring the ATS in line with the similar Torture Victims Protection Act by requiring exhaustion of local remedies. It seems odd, for example, that exhaustion is required for claims of torture or extrajudicial killing under the Tvpa, but not for a less heinous abuse alleged in an Alien Tort Statute suit. Even if, contrary to the U.S. position, an Alien Tort Statute based on conduct in a foreign territory can be entertained, an exhaustion requirement would protect our courts from wading into disputes more appropriately litigated elsewhere and could spur foreign governments to develop their own adequate means of redress. Now, in Sosa, the Supreme Court expressly, and I quote, welcomed any congressional guidance in exercising jurisdiction with such obvious potential to affect foreign relations. A bill introduced by Senator Feinstein in 2005, shortly after Sosa, would have resolved some of the problems that I identified, but it was withdrawn without the Senate taking any action. If Congress were to legislate, it could apply a clear statute of limitations for ATS claims and provide precise definitions of authorized causes of action. Again, much more like the Torture Victims Protection Act. A statute of limitations would prevent courts from resurrecting very old controversies that the foreign state has long since put to rest. Indeed, courts of appeals have already imported the TVPA's 10-year statute of limitations into the ATS, and state law limitation periods are also sometimes borrowed for federal causes of action. Defining causes of action legislatively would lend certainty and accountability to the litigation. Judges would no longer be left to divine causes of action in the unfamiliar materials of international law. And such definitions would embody the judgment of Congress and the President as to the content of international law. Another meaningful step might be to prohibit class actions. If Congress were to act, however, it should also proceed cautiously because of the great potential for suits in U.S. courts regarding conduct in foreign countries to interfere with our nation's foreign policy. Beyond the ATS, however, we also need to focus on the many other tools that the U.S. government, and in particular the State Department, can use to prevent and redress human rights abuses. Some of these are tools of persuasion. For example, the State Department's annual human rights reports, which review countries' human rights practices and focus attention on reported abuses. The State Department also conducts quiet and public diplomacy in bilateral and multilateral fora, and it administers a variety of programs intended to foster development of the rule of law in other countries, a critical aspect of preventing and redressing human rights abuses. And we also support voluntary multi-stakeholder initiatives to promote corporate codes of conduct in the developing world, such as the voluntary principles in the extractive industries. And at the same time, the United States continues to support holding foreign government officials and other persons criminally accountable when they commit torture or other serious human rights abuses. And as you know, this is an area that Professor Newton's been heavily involved in. In the cases of Rwanda and the former Yugoslavia, the United States has supported special international tribunals to try and punish the guilty. In addition, the domestic criminal law and jurisdiction of the United States is available to punish torture and genocide. For example, the federal government is currently prosecuting Chucky Taylor, the son of the former Liberian leader Charles Taylor, on charges of torture stemming from abuses perpetrated in Monrovia, Liberia in 2002. So we need to continue to foster these and other approaches to enforcing human rights. The problem that human rights enforcement must ultimately address, and for which the Alien Tort Statute is of little avail, is the failure of foreign countries' own domestic rule of law institutions to prevent and provide redress for abuses. These failures cannot be fixed by any single policy program or lawsuit, and certainly not by making U.S. courts ad hoc claims tribunals. Rather, inculcating a respect for law and human rights takes a sustained and careful effort focused on strengthening legal institutions in foreign states, not necessarily expanding the reach of our own. Thank you very much, and happy to take questions. And as Professor Newton said, I am happy to take questions. This is a complex area. I know some of you know it, and so I'm happy to focus them on the speech, but we do very interesting work in the legal advisor's office, so I am happy to take questions really on any area of international law that may be of interest to you. So the floor is open.
I have a few questions, and certainly don't intend to be confrontational, but I know that ATS has been used in the past, I'm thinking in particular to Unical, for aiding and abetting charges to hold U.S. multinational companies liable for very egregious human rights violations. And I'm wondering if we were to, and I know it's been severely limited in the case of aiding and abetting, but if we were to do that further, what are other means of reining in multinational companies when the violations of human rights are not happening in the U.S. And they're often in conjunction with the foreign governments, and so probably jurisdiction in the foreign country is not an appropriate means of redress. I'm thinking, I know Shell isn't a U.S. company, but Nigeria and the Shell situation in the past couple of years is another situation where I feel like multinational companies need to have some form of, there should be some form of redress.
No, you're absolutely right, and no worry about you are not confrontational. I'm actually used to a good deal of confrontation going around the world trying, defending. What I do, in part, in addition to providing legal advice inside the State Department, is to go and try to explain U.S. legal positions around the world, which, as you can imagine, are things that other countries don't always agree with when it comes to things like Guantanamo and otherwise. So I am happy to have as much civil confrontation as you would like. There's some good questions. I guess the sort of the premise of the question is that even if the abuses were actually carried out by the government, that we take as granted the plaintiff's allegations that the corporations really were somehow complicit. It's sort of unclear in a lot of these cases whether that's really right. It's clear that the governments were the ones that carried out the abuses, and since the governments are not being sued to sue the companies doing business in those areas, if we don't do, I've laid out the problems with doing it. You've asked the natural question of, well, okay, but if we don't allow this, but they really have, and take the premise they've done bad things, then how do you hold them accountable? I think the answer basically is through codes of conduct that we can have through legislation. As you know, Congress often steps in when it sees corporate actors that are engaged in bad behavior. It may require companies to treat their employees all around the world in a particular way. If they haven't, they can be required to subscribe to certain codes in the future. So I think there are other ways to go about doing it, and that is generally what we do. As I mentioned, the Alien Tort Statute does bring attention to some of these cases, and it does put pressure on companies. The State Department, though, will work with them to encourage them to reform their practices around the world. It's something that we get them to try to engage in voluntary codes. You look like you have a follow-up. So.
Interests, and so I view the executive and legislative branches to some extent to be rightly more concerned with national interests, and maybe the judicial branch should be rightly more concerned with victims' rights. So
right.
How do you balance there's no denying
Right.
that the executive branch has to take in multinational corporations because they are pretty big political, they have big political impact. So.
Well, I think the questions that you ask are good ones. I mean, what we find in government all the time, and this is a good area, is you have to balance these different equities. I mean, in any issue in government, the equities are never sort of all completely on one side or completely on the other side. And so you raise very good questions. I think what I've tried to provoke is we're maybe not really in a very good area right now because we have this statute that was intended for probably an entirely different purpose that plaintiffs have seized upon in a way that is causing a whole variety of different problems that we would be extraordinarily unhappy about if we were being sued in a foreign country for conduct that didn't happen there and for which the Congress has provided absolutely no legislative guidance. So it just sort of leaves it up to the courts to decide, well, what do we think we'd like to do? And so you raise a good question about, well, what should be done, but it may not be just simply up to the courts to figure out their own way, particularly given the costs that it has resulted in. Professor.
So, John, I found your remarks very interesting, and it seemed as if you were laying out a kind of comprehensive strategy. I mean, this was really a sort of soup to nuts overview of ATS litigation post-SOSA. And so, to the extent that there is a kind of comprehensive policy that you're articulating, I have a two-part question about it. So, one goes to sort of the timing of why now articulate the policy, and the second goes to the content of the policy and a question about some of the 5 issues that you raised. So, first with respect to timing, so you say, well, plaintiffs continue to push against the door that SOSA left ajar. Well, that's natural. I mean, the SOSA test, the 3 paradigms, is hardly a model of clarity. And so we would expect that plaintiffs push. They push in all areas of the law, not just the ATS. And of the examples that you mentioned, though, many of them were dismissed or are cases that are still pending and have been significantly narrowed or were by no means close to any type of final judgment. And the one case that you specifically focus on, which is the South African litigation, is highly problematic in many ways. But in some ways, I wonder about the possibility of developing policy based on what is an outlier case that is being remanded back to the district court and is by no way finished or even going to trial. And so I think many of these issues that you raise, some of which I'm sympathetic to, are likely to be resolved over time. Litigation of this nature is going to take a while, and so it's not clear that the lower courts can't do the kind of gatekeeping that Justice Souter said was required of them. So, so one question is sort of a timing question, and what are the exemplars that you use to set up the policy based on where we are in the evolutionary process? The second goes to the 5 issues you raised. Now, some of them make where you would welcome either legislative guidance or which would guide your submission of statements of interest. So some of them seem to make a lot of sense, right? So the SOSA test as to specificity clearly needs some improvement. Exhaustion of domestic remedies, there's an open question as to whether Congress, in enacting the Tvpa and essentially indirectly validating the ATS, didn't sort of speak to that issue for ATS litigation. But that's still a very live issue in the courts, especially over whether you have a selection of one statute over another. So those 2 are sort of specific. They certainly make sense. There are all sorts of strong arguments, I could say, on both sides. But when you mention extraterritorial application of the statute, that would really limit most, if not all, of the post-Florida litigation. And so it strikes me that some of the issues that you raise map very well into the problems that you've identified, and others seem to me to be overbroad. And so I wondered whether you might comment a little bit more on whether these 5 issues are really all part of a kind of comprehensive strategy, because if you win on the first, all the others really will fall away, or whether, in fact, the department's likely to emphasize some more than others.
Right. All good questions, as I would expect from a professor. It was an effort to really lay out a comprehensive discussion of this issue. Frankly, to my knowledge, this has been a big area for the State Department and the U.S. government, particularly over the last 7 years, and we've filed all these briefs, but no one has really ever spoken much about it. So this really was an effort to try to lay out in some detail what really has been a problem for us, without really trying to sound too negative. I mean, you'll have to tell me how I sounded, but the effort really is to try to put before an intelligent law school audience and say, look, here we are in the government, we're presented with these issues, and they really are causing some problems, and the Supreme Court sort of spoke to them and tried to clarify things, but it hasn't really had that effect, and so sort of what would you do? So it's sort of a problem solver. Why now? I'd say because we do have the Apartheid case before the Supreme Court, that we do, the two cases that have gone the farthest that are in the Second and the Ninth Circuit, both we think essentially got it wrong, essentially just ignored what the Supreme Court said. It was if the Sosa was just sort of a speed bump in the road, and they have just kept on going as if Sosa never happened. Sosa clearly just basically said, the Alien Tort Statute was intended just to provide these three causes of action from the 1790s, plus, so it's kind of hard for us to say, well, it can't have anything, a few other cases, but courts, be realistic, keep it limited. And the courts have just not done that, at least the two that have gotten the farthest. And then the Apartheid case, in addition, is truly remarkable in that the Supreme Court itself dropped a footnote, which you've probably looked at far more cases than I have, but I mean, it's either unique or highly unusual for the Supreme Court to note a district court case that's on its way up and essentially signal that that's an inappropriate case for federal courts to take. The district court in that case took the hint and dismissed. Second Circuit said, nah, we'd like to go ahead anyway. It's an effort now to talk about the issues that are confronting the government. For us at the State Department in particular, and hopefully some of this came through, we spend an enormous amount of time that we had not really expected to have to spend, which we would otherwise be spending, in fact, doing treaty negotiation, dealing with issues in foreign countries, literally supporting the work of our policymakers in promoting human rights and rule of law around the world, getting pulled into these cases because the courts either ask for our views, so we have to write briefs, or the foreign governments come to us and say, you've got to go in. So it's an effort to sort of explain this problem. On the second point, I wouldn't say every one of these issues has got to be solved. I've tried to lay it out in somewhat more of an academic way as to what are the problems that are out there. I think the courts can and may in some areas be moving in the right direction to resolve some of them. If the Supreme Court takes the next case, which I think they will probably, if they take it, it wouldn't surprise me if they express a little bit of irritation to say, gee, we just took this case in 2004, and here we are again. Lower courts didn't listen to us, so that may resolve things. But as I've suggested, and as the court itself said in Sosa, maybe Congress really needs to, through a more politically accountable and democratic process, provide some more guidance on things like, what sorts of cases really should be brought? Should there be a statute of limitations? Are we really comfortable having our courts consider these actions that took place wholly in foreign countries? So I don't know that every one of the issues needs to be resolved, but they are open issues that Congress has not spoken to. In the Torture Victims Protection Act, they obviously did say our courts can look at certain cases that occurred only in foreign countries, but in a very limited way. These ATS cases actually have the potential to cause far greater problems than the ATS.
Two quick questions. First, how does the principle of ne bis in idem, or double jeopardy, affect the hearing of cases currently in our courts, and how might it affect future courts hearing it in perhaps a more proper domestic fora? So, foreign nationals bringing courts here, how is the principle of double jeopardy going to affect them bringing cases in their own courts later on if if they were able to do so or if they changed their mind for one reason or another. And then my second question is, and this is more of a basic question, but how does the fact that our courts rely on the principle of stare decisis, whereas all the other international courts are not, and essentially this is converting the U.S. court into an international court in these cases, how does the fact that we rely on stare decisis and the other courts not just generally affect the growing body of international law on these issues?
Well, on double jeopardy is really a criminal concept that if you're tried once and are not convicted, then you shouldn't be tried again. I mean, in civil actions, you can have civil actions against. You can have them in federal courts. You can have them in state court. You can have them domestically. You can have them internationally. So often companies or private actors are sued in multiple jurisdictions around the world. I'm not sure I fully understand your second point on stare decisis. The international tribunals are, while they're not as closely bound by precedent as our federal courts and state courts tend to be because of our common law system of precedent, I mean, they certainly build on previous precedents. If you look at an International Court of Justice opinion or some of the ICTY criminal tribunals, they will certainly cite their previous rulings and build upon them.
Maybe time for one more question, and there is a reception room, so please stay for the reception.
I see two questions, and then we will go. Here and here. How about down here first?
I just want to follow up on your answer to the first question. And that is, it seems to me there's lots of other ways to change corporate behavior without litigating.
Yeah.
Shareholder pressure, consumer pressure. If shareholders don't like what corporations are doing, they can put pressure on management. Consumers can stop buying those products or boycott those companies. I'm not the least bit pessimistic that if we stop litigating, that's the end of our recourse as the American.
Well, that's good. I think you actually gave a better answer than I did, so those are good points.
And one question as well, and that is, rather than seek substantive changes to the ATS, I'm just curious why you can't get a lot of traction in dismissing these suits through procedural mechanisms such as foreign non-convenes. If all the conduct is taking place in a foreign country, it would seem right for that kind of doctrine that dismisses the case and says it should be litigated in a different venue.
Right. I mean, in general, the corporate or private defendants will raise all of these jurisdictional objections. They will raise objections under the Alien Tort Statute saying, aiding and abetting is not actionable, but then they will raise all these normal jurisdictional defenses. Often, and Professor Elfer probably studied more of the cases in detail than I have. Some courts will dismiss on some of those grounds, but there are a number of courts, and including the courts in the Second and Ninth Circuits, that seem to find their way through these to say we just want to hear these cases.
You talked about problems with the ATS from the perspective of the executive branch and sort of past-looking, but I have a forward-looking question, which is, based on your understanding of the ATS and sort of the wide scope of the case law and its interpretation, the administration the current administration, which will soon leave office, those individual members of the administration, you mentioned Guantanamo, Abu Ghraib also comes to mind. There's certainly the potential for lawsuits and civil liability by individual members of the administration based on conduct that could be considered torture and therefore actionable under SOSA. So one, I'd just like to get your thoughts as to the potential application of the ATS, not the human rights abuses that occur by nationals, but actually by U.S. government officials. And secondly, get you to comment on the impact that possibility has on the executive branch's position currently on ATS litigation, which could be viewed cynically as an attempt to limit the scope of potential liability for current members of the executive branch who may soon face liability under these various statutes in the coming years.
Well, I mean, you raise what is a legitimate concern, but I wouldn't connect the dots in that way. I mean, there is a concern about actions brought against our officials, and there have been a number that have been brought around the world. And in fact, that's one of the the inconsistencies that we are accused of with respect to the Alien Tort Statute. For example, there have been cases, either civil or often under universal criminal jurisdiction statutes. As some of you know, there's in a few places there are these odd universal criminal jurisdiction statutes. Belgium had one that allow essentially a private plaintiff to go to court to bring a criminal action in a foreign country for a crime against humanity. There were some that were brought against Secretary Rumsfeld in Belgium. They've been brought against Henry Kissinger in France, and then also civil cases. And we are concerned about those, and we go and tend to be quite diplomatically forceful with these governments. We actually got Belgium to back down on and revise the laws in its universal jurisdiction statute. And then when their officials are sued at our courts, they come back to us and say, well, what about the double standard? So yes, to a certain extent, the U.S. government, people should be held accountable for human rights abuses. We have a very robust policy of supporting international criminal tribunals and investigations for human rights abuses around the world. But we also think that certain conduct should be immune and should be protected. Normal diplomatic activity. Henry Kissinger is now still being chased all around the world 35 years later for allegedly turning a blind eye to abuses in South America. So yes, that's a concern, but it's not what motivates us with respect to the Alien Tort Statute. The Alien Tort Statute concerns, which we do have concerns, are really more the ones that I laid out, which is this double standard with respect to other countries, the diplomatic costs, the fact that the courts are just simply being left to their own devices. So, I mean, you raise a fair point that we are concerned about suits against our own officials around the world, but it's not so much that we are concerned that the ATS might be used against them. So, well, thank you all very much for coming. And I look forward to seeing you all at the reception. I have to say, this is a pretty esoteric topic, and I really appreciate you all coming and listening and, in fact, asking some very good questions. So look forward to seeing you afterwards.
Well, if there's any